Welcome to the West Virginia Board of Osteopathic Medicine's first educational series about the regulation of medicine in the state of West Virginia. In our first module, we're going to discuss why medicine is regulated at the state level and why state medical boards are the appropriate mechanism through which the state should regulate medicine. We're excited to share this information with you, and we hope that you find it useful. Welcome to Module 1. In this module, we will discuss why the practice of medicine is regulated by the states and why the regulation is performed by state medical boards. Whether you're a medical provider, someone working in a medically related field, or a member of the public hoping to learn more about the structure and function of medical regulation, you're in the right place. In this course, we will be referring specifically to the rules and regulations of the state of West Virginia, but most, if not all, of these concepts apply to other states as well. My name is Jonathan Osborne. I'm an attorney, and I'm the director of the West Virginia Board of Osteopathic Medicine, which is one of two licensing boards regulating physicians and physicians' assistants in the state of West Virginia. Each state has a medical licensing board, and 14 of those states, including my state of West Virginia, have both an allopathic, or MD board, and an osteopathic, or DO board. If you include the medical boards operated by U.S. territories such as Puerto Rico, Guam, the U.S. Virgin Islands, and the Northern Mariana Islands, there are 71 total medical boards in the United States. But why is that necessary? Or, asked another way, why do we regulate medicine at the state level? Why doesn't the federal government regulate medicine? To answer that question, or those questions, I guess, we have to take a brief detour into constitutional law. Now, constitutional law can be complicated, but what we need to know for our purposes here is pretty straightforward. And that is that the U.S. Constitution limits the power of the federal government to those powers specifically enumerated or set forth in the Constitution. There's a reason for this. In the summer of 1787, when our founding fathers were drafting the Constitution, they still had fresh in their minds the expansive power that the British Parliament held at that time, and the lack of any real checks on the British Parliament's power. As colonists, they also had little voice in government and little protection of individual rights. The British government had been restricting colonists' rights to fair trials and imposing taxes without colonists' consent, and doing a lot of other things that made our founding fathers hesitant to create a federal government where any one person or group of people could hold that much power. Our founders thought that there was a better way, so they created 3 branches of the federal government instead of one, giving each separate powers and ensuring that each could check the power of the other 2 in some way. And we all know those branches from school. The legislative branch was vested with the power to make laws, the executive branch was vested with the power to enforce laws, and the judicial branch was vested with the power to interpret laws. Article 1 of the Constitution, which vested the legislative branch with its power, also placed a limit on the federal government's authority to enact laws in what we call the Necessary and Proper Clause. That clause limits Congress's power to enact laws to only what is, quote, necessary and proper for carrying out its enumerated powers. But what about laws that may be needed for things that fall outside of the powers given to the federal government? Well, for that, we have to look to the 10th Amendment. The 10th Amendment states that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states, respectively, or to the people. Now remember that the Bill of Rights, the first 10 amendments to the Constitution, were considered to be recognizing and protecting existing rights, not creating them. The rights recognized in the Bill of Rights were believed to have come from God or nature and not from the government. So the 10th Amendment was really a recognition of what the founders believed to be apparent already, since they had given the federal government limited power to begin with. All other power belonged to the states and the people. This power reserved to the states in the context of constitutional law is often referred to as the police power, and is described as a state's ability to enact laws for the health, safety, and general welfare of its citizens. It's under this health, safety, and general welfare umbrella that we find the regulation of the practice of medicine, and why, in the United States, we find medicine regulated by the states instead of the federal government. The final piece of our discussion about this constitutional background is understanding that the practice of medicine, because of its direct effect on health and safety, is not considered an inherent right like one's ability to earn a living or carry out one's chosen occupation might be in some other context. Instead, the practice of medicine is considered a privilege granted by the states. And this brings us to an interesting piece of West Virginia history, because the precedent for this assertion that the states have the authority to regulate the practice of medicine and to limit who can practice it comes from a Supreme Court case involving a West Virginia doctor and the newly established Board of Medicine. That case is Dent v. State of West Virginia. Now, Frank Dent, who was the Dent in Dent v. State of West Virginia, was a physician who practiced with his father and grandfather in Newburgh, West Virginia. He learned the practice of medicine by apprenticing under his father, which he had been doing for 6 years when the state of West Virginia passed its Board of Health Act in 1881. The Board of Health Act said that anyone who wanted to practice medicine in the state had to show one of three things. A practitioner had to show that they had either received a diploma from a reputable medical school, that they had already practiced medicine in the state for at least 10 years, or that they had successfully passed a state-administered exam. Frank didn't meet these qualifications. He had only been practicing for 6 years. So he headed off to Cincinnati, and by 1882, the following year, he had received a degree from the American Eclectic Medical College of Cincinnati, and he sent his diploma to the West Virginia Board of Health. But the board said, whoa, that is not a reputable medical school. This made Frank angry, and in an attempt to force a legal showdown, he began openly practicing in defiance of the board. In response, the board notified the Attorney General, who had Frank Dent arrested. At his trial, Frank had his cousin Marmaduke represent him. Now, aside from having a great name, Marmaduke Dent also was the first graduate of West Virginia University, and he later served on the West Virginia Supreme Court. But even with Marmaduke representing him, Frank was found guilty of practicing without a license. He appealed his case to the West Virginia Supreme Court, who upheld the circuit court decision. So he appealed it again, this time to the United States Supreme Court, where Marmaduke claimed that requiring a medical license was a violation of his cousin's due process rights under the 14th Amendment. The Supreme Court at that time had a large backlog, but finally heard his case more than 5 years later, where they found that requiring a license to practice medicine wasn't a violation of the Constitution. The court's opinion set out a lot of important things for the way we think about the regulation of medicine today. The court's opinion began by recognizing a right to follow a lawful calling, but it said that there was a higher societal right to having reasonable conditions met that would protect the public. Justice Stephen Field, who wrote the majority opinion, wrote that the power of the state to provide for the general welfare, remember that's that police power we were talking about earlier, authorizes the state to prescribe all such regulations as in its judgment will secure or tend to secure them against the consequences of ignorance and incapacity, as well as deception and fraud. But Field also noted that the state didn't have absolute authority here. He wrote that qualifications set for practicing a profession had to be both appropriate and attainable. But he then went on to say that few professions require more careful preparation than medicine. Finally, the court recognized some things that are the foundation of the way we think about and organize professional licensing boards today. The court said that few can judge the qualifications of learning and skill which he, in this case Frank Dent, who was a physician, possesses. Reliance must be placed upon the assurance given by his license, issued by an authority competent to judge in that respect, that he possesses the requisite qualifications. This statement from the Dent opinion really emphasized the fact that the public as a consumer was ill-qualified to judge a physician's qualifications, and that it was important that they could rely on somebody who could. It also implied that the ability to make those judgments should come from others within the field who understand the nuances and complexities of, in this case, medicine. This idea of self-regulation is what we find today in licensing boards from all professions. And that, in a nutshell, is why the practice of medicine is regulated at the state level and why medical boards are given the authority to oversee that regulation. So let's quickly review. We discussed today that the US Constitution set up a system where the federal government was granted limited power, shared by three co-equal branches. We discussed that the legislative branch was given the authority to enact laws, but that the authority given to the legislative branch was specifically limited by the necessary and proper clause. We talked about the 10th Amendment that reserves power to the states to pass laws related to health, safety, and the general welfare. And finally, we talked about the U.S. Supreme Court's decision in Dent v. West Virginia, where the court upheld the right of states to require a license to practice medicine. Make sure to join us for our next module, where we'll continue to explore the licensing, regulation, and discipline of physicians and physicians' assistants at the state level.